Is everyone ready to proceed?
We are, Your Honor.
Yes, Your Honor.
Just making sure, is Mr. Patterson here? I just want to make sure for our next witness, we're ready to proceed, Your Honor.
Yes, I'm here.
Okay, yes. So yes, thank you, Your Honor. We're all here.
All right. Is Dr. Lelotis here? For the witness, Mr. Lelotis? He's apparently not back yet.
Your
I
Honor, I can reach out to him and confirm that he's in the waiting room.
If it helps, Your Honor, I have no questions for him.
Neither do I, Your Honor.
It doesn't help.
Okay, I apologize.
It's okay.
Judge Poovey, this is Kelly Myers. He is not in the waiting room.
Thank you, Ms. Myers.
Yes, sir.
Mr. Simmons, if you could reach out to him, let him know that we're waiting on his return.
Certainly, Your Honor. I'll do that right now. Your Honor, I have reached out to Professor Lelotis, and he should be joining the waiting room shortly.
Judge Poovey, this is Kelly Myers. Mr. Lelotis is now in the session.
Good afternoon, Mr. Lelotis. Are you with us?
I am, thank you. Sorry, I thought I was done. Sorry about that.
That's okay. I believe that Judge Ofalu has a couple questions for you.
Oh,
So,
yes, certainly.
Judge Ofalu, I'll give you the floor.
Good afternoon, Professor.
Good afternoon. Again, my apologies.
Well, no, I want to apologize to you for calling you back onto the hot seat. It's totally understandable that you thought you were done. And I also want to apologize and disclaim that the fact that I may ask you a few questions may invite some follow-up questions from the attorneys. But
Certainly.
I wanted to bring you back to some questions and answers that were given in your testimony about the ability of registered voters to obtain a photo ID at an early voting site by giving their last name, first name, social security number at the same time that they could vote if they wanted to in the early voting. You recall those questions?
Yes, and I think that's right, yes.
Okay. And is that your understanding of what the current iteration of the voter ID law is, that in fact that is true?
I believe it is.
What is your understanding of when that part of the voter ID law that allows that provision that I just went through came into effect? Did it come into effect December 6th of 2018? In other words, in the original, or did it come in through an amendment that has happened since then?
My memory is that it was an amendment.
Okay. So that leads to my question. When you wrote your initial report and also your subsequent report, was that part of your understanding when you wrote those reports?
It was not.
Okay. So, how would then, if that was not part of your understanding, how would the addition of that additional fact that a registered voter could possibly vote at the same time that they obtained a photo ID without presenting governmental documentation, how would that affect your opinions?
Well, two things. I think as I answered, the questions from legislature's counsel, it seems to me that a lot of the concerns I have would still stand. I think the other thing I would do from a historical perspective would be to look back at House Bill 589 and look back also at North Carolina election law while Jingles v. Edmonston was being adjudicated, that ruling, of course, in 1984. And in both of those examples, lawmakers, when election law was being contested in the 80s, and again, while 589 was being contested, made those kinds of 11th hour adjustments to the law. And of course, in the case of Jingles, the court actually called that out as a bit too little too late and perhaps not sincere. I don't make that judgment here, but I would just note the historical parallels to those two prior instances.
Okay. Just a couple more follow-up questions. Of course, if you attempted to go on election day and you either did not have a qualifying photo ID or you had not previously made a stop at the DMV or the County Board of Elections, that would be, of course, a barrier and an impediment to voting on that day, correct?
That would be, and I assume the process, again, you'd have to come out of the line in some manner to get that that qualifying ID at the polls.
Right. Okay.
So that would worry me about creating in effect two classes of voters.
And the last question, I haven't your reports and evidence, and I've listened carefully to your testimony, but obviously, while I'm listening, have not been able to read your reports at the same time, or at least have a thorough understanding of them. But was there anything in your report, did you factor in, sort of the hassle factor of having to wait an extra time to get both a photo ID and vote at the same time? In other words, the delay, we often see lines at polls and things like that. Is that part of your analysis?
It was not a part of my analysis, when I was writing the report, but it seems to me that it, is clearly something to be concerned about.
All right. Well, thank you, Professor. Those are the questions that I had.
Sure. Thank
I'm
you
going
very
to send
much.
it back over to you, Judge Poovey.
Do any of the lawyers have any follow-up questions for this witness based upon the questions from the court?
Yes, Your Honor, I just have one or two, if I may.
You may.
Thank you. Professor, just so the record is clear, you understand that SB 824 was passed by the legislature in December of 2018. Is that right?
Yes.
And is it your understanding that this law, from the time of its passage in December of 2018, had one-stop early voting where you could get the free ID? Or is that not your understanding?
That is not my understanding.
Thank you. I have no further questions.
Mr. Cox or Mr. Simmons, do either of you have any other questions of this witness based upon the court's questions?
Just have a very, very brief clarification. If I could share my screen, Your Honor.
You may. Just Mr. Cox, just make sure you state your name when you begin talking. It's hard to know who's talking unless you state your name.
Thank you, Your Honor. So this is Paul Cox from the Attorney General's office again, and I'm showing what has been marked as Exhibit JX 413. This is Senate Bill 824. Do you see that, Dr. Laludis?
Yes, I do.
And I'm going to scroll down to the bottom just so that you have the benefit of seeing the ratification information at the bottom. You see there that this session law became law notwithstanding the governor's objections on December 19th, 2018.
That's correct.
Okay. And I just want to point your attention to part 1 here, section 1.1a. Do you see where it refers to the voter photo identification cards?
Yes.
Okay, and specifically, I want to bring you down to subsection D 2.
Yes.
Do you see that where it says voter photo identification cards shall be issued at any time except during the time period between the end of one-stop voting for a primary or election as provided in GS 163A-1300 and election day for each primary and election?
Yes.
Does this indicate to you that the allowance for issuing county board issued photo identification cards during one-stop voting was always part of the law?
It does to appear, at least sitting here reading this, to have been part of the law. You know, what strikes me is the gap.
The gap.
Between the opportunity up to the end of one-stop voting and then election day.
No further questions, Your Honor. Thank you.
Your Honor, may I just have a brief, excuse me, indulgence to discuss with my colleagues? Thank you. Your Honor, I just have one question for Dr. Laludis.
Very well, you may proceed.
Dr. Laludis, even if it is a requirement that all counties are allowed to offer free IDs, or excuse me, I'll strike that. Dr. Laludis, even if Senate Bill 824 permits counties to offer free forms of identification at early voting sites, are you aware of any mandate that a county has to offer this free ID at every single early voting site?
I am not.
Thank you. Your Honor, that's all the questions I have.
All right, further recross examination.
Not from the legislative defendants, Your Honor. Thank you.
No, Your Honor. Thank you.
All right. Thank you very much, Dr. Laludis, for your testimony. You may step down, you may leave the group, and you're also welcome at this point. You're not under sequestration any further, so you can view the proceeding if you so desire.
All right. Well, thank you. And my apologies again to the court for the technical difficulties in the early exit. I know this has been a long day for everyone, and
There's no reason.
Sorry to have extended it.
No reason to apologize at all. It certainly wasn't your fault. Thank you, sir.
All right. All right. Good day.
So Ms. Riggs, are you ready to call the plaintiff's next witness?
Yes, Your Honor, I'll turn over to my colleague Hillary Cline to call plaintiff's next witness.
All right. Hillary Cline?
That's right. Good afternoon, Your Honors. I don't think I've had the pleasure of addressing the court yet. My name is Hillary Harris Cline with the Southern Coalition for Social Justice on behalf of plaintiffs.
Good afternoon, Ms. Cline. Welcome.
Thank you very much, Your Honor. If it please the court, plaintiffs call Sabra Fairs to testify.
All right, Ms. Fairs, are you present and can you hear me?
I am present and I can hear you.
Very well, thank you. If you could please, could you raise your right hand? Ms. Beal, are you on the line?
Yes, sir.
Would you like to swear in this witness then, please?
Of course. Do you solemnly affirm that your testimony to the court will be the truth, the whole truth, and nothing but the truth, and this is your solemn affirmation? I do. Thank you. You can lower your hand.
Ms. Cline, you may examine the witness.
Thank you, Your Honor. And good afternoon, Ms. Fairs. Could you please introduce yourself to the court?
Hello, my name is Sabra Ferris, and I provided an expert report for the case.
Can you tell the court your current occupation?
I am an attorney in private practice in Raleigh.
And where were you working before you were in private practice, if anywhere?
For decades, I worked at the North Carolina General Assembly in various capacities. I started in 1980 in the bill drafting division of the General Assembly. I worked there until about 1987. I left there and went to work for another agency. I worked for the Office of Administrative Hearings, which conducts contested case hearings. I was a staff attorney there. I've worked with the Rules Review Commission as a staff attorney as well. After that, it's 2 years. I rejoined the legislative staff and I went as a member of the fiscal staff and became a principal legislative analyst. And in that job, I continued what I had done in the bill drafting division, which is draft bills, amendments, committee substitutes, conference committee reports, explain the law both orally and in writing. And then I did a lot of committee work then as well. I was staff to the House and Senate Finance Committees, for example, along with revenue laws and numerous other committees. I remained at the legislature until 2003. No, I'm sorry, that's not right. So after I came back, I left the legislature in 97 and went to the Department of Revenue, where I was an assistant secretary for tax administration. And then in 2003, I once again returned to the legislative staff, this time as the general counsel and chief of staff for then co-speaker Richard Morgan. I served in that capacity for 2 years, and then in 2006, I joined the staff of then President Pro Tem Mark Bassine as the tax counsel to the Senate. So on and off, I've worked over 21 years at the General Assembly in various staff capacities. Since that time, during that time and then afterward, I was also the chair of the legislative committee for the tax section of the North Carolina Bar Association, and I serve on the General Statutes Commission since 2012.
With reference to your work for the General Assembly, did any of this work require knowledge of legislative procedural issues?
Yes, all of it required knowledge of legislative procedural issues. Those issues arise in every aspect of legislative work. Legislators constantly ask questions such as, does this bill have to be read on separate days, meaning second and third readings are on separate days? Is this bill subject to the crossover deadline? Is this motion in order?
I'm sorry. I'm sorry. I totally lost you there. You said, does Does this bill have to be read on separate days, meaning second and third readings on separate days? Is this bill? And then I didn't understand what you said.
I think I said eligible for since that did meet the crossover deadline. Can this matter be incorporated into a conference committee report? Just a myriad questions such as those are involved every day at the General Assembly.
And did any of your work with the General Assembly require you to research legislative history or standard legislative practices?
I typically research legislative history when working on proposed legislation. Legislators frequently want to know what has happened in the past with proposals of that sort, and so that they can avoid pitfalls from the past, but also be aware of concerns that may have been raised in the past. And as to research as to procedure, except for reference to the rules, I can't say that there was research about procedure, except through what happened to bills through bill histories and other legislative documents.
And while with the General Assembly, about how many bills did you advise on that moved through the legislative process in North Carolina?
Well, throughout my tenure, it would have been thousands of bills.
Your Honors, if it pleases the court, I would like to move Ms. Ferris to be admitted as an expert witness of North Carolina's legislative practices, norms, and procedures under North Carolina Rule of Evidence 702 on the basis of her knowledge, skill, experience, training, and education.
Is there any objection to that from the defendants?
Not from the legislative defendant, Your Honor. This is Pete Patterson. I'll be hearing for legislative defendants for this witness.
Okay, thank you. How about for the state defendants?
Not for the state defendants, thank you.
All right, the witness is received as an expert within the field so tendered. May I ask your next question, Ms. Cline?
Thank you, Your Honor. Ms. Ferris, you testified earlier that you had submitted an expert report in this case. Your Honors, if it please the court, I'd like to publish that exhibit. It is previously marked JX31.
Yes, ma'am, you may publish that exhibit. Thank you.
Thank you, Your Honors. And just so I know going forward, if I intend to reference or show and publish a joint exhibit, would the court like me to forecast and ask permission each time?
No, assuming the exhibit has been received into evidence, we simply would like for you to reference it by exhibit number and by a brief description so that others wanting to look at it or look at other parts that are not being published can do so. But if an exhibit has, by joint stipulation or otherwise, been admitted already, then you can simply refer to it by exhibit number and a brief description of the exhibit, and you need not ask my permission to publish it.
Thank you, Your Honor.
Thank you for asking. There's others that haven't asked. They just put it up there, but that's good.
And just to be clear, as yesterday we got through a section of the joint exhibits that are to be admitted in this matter, I believe that the joint exhibits I'm going to be referencing have not been gone through that formal process of reading them through the court. But if I understand the court correctly, if the parties have agreed that these things can be admitted into evidence at some point, I need not ask the court's permission. Am I understanding that correctly, Your Honor?
Perfectly correctly. Thank you.
Thank you, Your Honor. Ms. Ferris, do you recognize this document?
Yes, I do. It's my expert report.
And can you tell me briefly, what were you asked to do in this report?
I was asked to review the process by which Senate Bill 824 was enacted to determine if that process followed the normal practices of the North Carolina General Assembly.
And briefly, can you tell the court how you went about evaluating that?
I reviewed the volume of materials that are listed in Appendix A of my report to determine the facts concerning legislative practices. Those materials include House and Senate journals, session laws, bills, resolutions, statistics that have been compiled by the Legislative Library of the General Assembly, and also statistics compiled by Professor Joe Farrell from the School of Government. In addition to that, I looked at a few court cases challenging the constitutionality of various acts of the General Assembly.
And you'll see on the screen, we've gone to JX31, PDF page 33, Appendix A to your report. Does this list the materials that you were just talking about and describing?
Yes, it does.
Thank you. Ms. Ferris, did you use any of the skills you had developed through your experience with the General Assembly in preparing this report?
I did. In looking at all the information, a practiced eye is always helpful. The bill histories are not always self-evident, nor are the House and Senate journals or the statistics that have been compiled about various matters.
You testified that you were asked to evaluate whether the process for Senate Bill 824 followed the standard legislative practice. Can you tell me how you determined what that prior practice was for the purpose of your report?
I'm sorry, I started before you stopped.
I've completed my question. Thank you.
I determined it based on what had happened at what the General Assembly had done in the past.
And
because the General Assembly itself establishes its own norms.
And as far as describing something as a norm, did you have any specific way of determining something was a norm?
I determined something was a norm by establishing whether or not it happened more often than not.
As a general matter, Ms. Ferris, are legislative norms altered because of changes in the membership of the North Carolina General Assembly?
No, those norms are not. Those norms are developed over time and through their practice. And are not member specific.
Sorry, I didn't understand what you said after practice.
I said they're not member specific.
And as a general matter, are legislative norms altered because who sits in the governor's seat has changed?
No.
Ms. Ferris, could you summarize briefly for the court the conclusions you reached in your report?
Yes, I concluded that the process by which Senate Bill 824 was enacted did not follow the normal practices of the North Carolina General Assembly.
And can you briefly describe on what basis you determined it was not the normal practice?
I compared the bills that were the specific bill, Senate Bill 824, to other bills implementing proposed constitutional amendments. And I compared the type of session in which it was enacted to other types of sessions of the General Assembly.
Ms. Ferris, do you have any corrections you'd like to make to your report today?
Yes, I do. There are 3 corrections to make, actually 4. The first is to a footnote. It's a citation on page 8, footnote 13, now cites to a session law when it should cite to a bill. It should cite to House Bill 351 of the 2011 session, because that was the bill that was introduced concerning voter ID. It did not pass because it was vetoed, so it wasn't a session law. That's an incorrect citation. The other changes are...
I'm sorry, Ms. Ferris. I will note for the record that we've shown on the screen JX31 at PDF page 11. Thank you, Ms. Ferris. I'm sorry I interrupted you.
No, the other 3 corrections are to Exhibit 8.
Can we go to JX31 at PDF page 106, please? What was your correction to this exhibit?
The corrections to this exhibit are for the date ratified on 2 of the pieces of legislation. In the column that shows date ratified, if you look for 2003-04, the amendment that was about school funds and forfeitures was actually ratified on July 18 instead of August 7. And the amend magistrate term was actually ratified on July 17. So those are 2 corrections to those dates, which, but once you make that change, you notice that another correction is needed to the date introduced on amend magistrate term, because that would put it being introduced the day before it was ratified. And actually that should be changed to April 8th of 2003, because there was a separate bill, a separate House bill that was enacted during the 2003 session that was incorporated into that Senate bill. So the proposed constitutional amendment, the substance of it plus the implementing legislation had actually been introduced in 2003. So
I see on this page, there's a calculation of average days at the bottom and average days since 1985. I'm going to ask you about the meaning of those later on. But for now, could you just tell the court whether the corrections that you here described impact those averages at all?
they do, they make the average days longer. And they increase the average days, both average days, the first one, and then average days since 1985. They increase them by about 30 days.
And do any of these corrections that you've described change the opinions you reached in your report about the legislative process for Senate Bill 824?
No, they do not. In fact, it makes a slightly stronger argument because when we get back to this, the average number of days has increased instead of decreased.
Thank you, Ms. Fairs. If it pleases the court, I would like to enter into evidence Ms. Fairs' expert report as here corrected. That's JX 31. And as stipulated by the parties, I would like to enter this as evidence of testimony in this matter.
JX 31 is received into evidence.
Thank you, Your Honor. Ms. Fairs, can you describe generally what kind of legislative sessions the North Carolina General Assembly can hold?
Yes, the North Carolina Constitution recognizes 3 kinds of sessions. One session is the regular session, and that is the principal session. It consists of 2 components, typically a long session that starts in the year after the general election. The term typically starts in January. It always starts in January because the statute requires it, and it typically ends in July, around July. The second component of the regular session is a short session that convenes after the primary in the even-numbered year and lasts until about the same amount of time. The short session is focused primarily on adjustments to the biennial budget that was enacted in the long session. A second type of session are extra sessions. The Constitution allows the governor, upon extraordinary occasions, to issue a proclamation calling the legislature back into session. The Constitution also allows the legislators themselves to call themselves back into session by a written request from 3/5 of the members of the House and the Senate. So those are extra sessions. And then there's a veto session. And as the name implies, if the governor vetoes a piece of legislation and the legislature has adjourned, then the governor calls the General Assembly back in session for the sole purpose of considering an override of the veto. And generally, I think of an extra session as lightning strike, whereas the regular session is a siege. The regular session is the place for the primary consideration of legislation. And another aspect of the regular session is that the regular session can be reconvened in other phases, and sometimes is. In most years, it's not. In most years, it's simply long session, short session, but in 5 years, the legislature has adjourned a regular session to reconvene on a specified date. And when they do that, the legislature continues what it started during that regular session. Those reconvene sessions typically address just a tiny handful of topics. If you think of the consideration of all legislation as a funnel, the long session is the top of the funnel. When the long session starts, there are no restrictions on the types of bills that can be introduced based on their subject matter, and there are bill filing deadlines, but you can introduce a bill on any subject in the long session. So as the long session progresses, when the long session adjourns, an adjournment resolution is adopted that sets the date that the next session of the next phase of this regular session is going to convene. And when that happens, the adjournment resolution specifies the subject matter that can be considered in that reconvened session. Typically, for the short session, it includes the budget matters, bills that met the crossover deadline, recommendations of study committees, bills that make appointments, and just a few others. As the regular session is the top of the funnel, the short session comes into the middle, and then if there's a reconvened session that's a continuation of the regular session that's neither the long session or the short session, it's the tip of the funnel. Typically, that session is limited to just a few topics that couldn't be completed in the long or short sessions.
And you described these regular sessions as a funnel. Can you tell me, did the 2017-2018 legislation follow this typical legislative progression you've described?
It did, except for the 2018 reconvened session that occurred after the general election. The General Assembly met several times in reconvened sessions between the long session and the short session. And in each of those reconvened regular sessions, there were adjournment resolutions that specified the topics. And Exhibit 5 of my report shows the list of topics for every reconvened session. So that fit the funnel. The long session was the top, the short session would be the middle, and then those regular reconvened sessions were the tip, except for the last reconvened session. And that is the regular session that was reconvened after the general election. Unlike every reconvened session in the history of North Carolina, the adjournment resolution for that session did not set any limits on what could be introduced. It was an open-ended session, and in fact, the resolution itself that authorized that, 2018-10, specifically states that the bill filing deadlines and restrictions that applied in the short session otherwise applied in the permanent rules of the 2017 sessions don't apply. So that's a very notable difference. And that is exhibit number 4 that lists every session, regular reconvened session, and indicates whether or not it was limited to a list of specified topics. And in that exhibit, every one is yes, except for this session, when the answer is no. There were absolutely no limitations on what could be considered in the session that started after the election.
So using your funnel analogy that you testified about earlier, what did the 2017-2018 legislative session look like?
That session would have looked like a, I guess, an hourglass where you start with what looks like a funnel, but then you go out wider at the bottom and you become even wider than the long session in some respects, because there weren't even bill filing deadlines or other restrictions on when legislation could be introduced.
Thank you. Your Honors, I would just note for the court that I'm at a logical stopping point. I know that it's been the court's practice to reserve the last half hour of each day for housekeeping. And I just wanted to stop to check in with the court to see if you'd like to do that today or if I should just keep going.
I guess we're close enough to go ahead and enter that housekeeping phase. I was planning on stopping at 4:30, but we're not, but we're 5 minutes out from that. So yes, it's a great place for you to stop, and we can go ahead and stop with the testimony at this point. Ms. Ferris, are you available tomorrow morning at 9:30 to be back ready to continue your testimony?
Yes, Your Honor, I am.
All right, thank you. We'll see you then. And I don't know, Ms. Cline, if you want to sort of pick up where Mr. Simmons yesterday left off, or whether Mr. Simmons, you're ready to go back to where you were as far as introduction of joint exhibits. The last ones that I have from yesterday were sort of captioned as demographic info published by North Carolina state agencies, and it was 713, 808, 811, and 820. So is it Ms. Cline or Mr. Simmons that's going to pick up the baton?
Your Honor, I'll pick up the baton if you'll just allow me a brief indulgence to pull up the chart where I saved my place from yesterday afternoon.
Sure.
Yes, Your Honor, I will defer to my very knowledgeable colleague on this issue. Thank you, Your Honor.
Okay, we'll see you tomorrow.
Okay, Your Honor, I'm ready to resume these joint exhibits for admission whenever you are.
I'm ready.
Okay, so Your Honor, the next category I have among the list of joint exhibits that the parties have agreed can be moved into evidence. These documents are information published by the North Carolina Department of Motor Vehicles, and the joint exhibit numbers are 710, 711, 714, 715, and 869.
Okay, so just to be clear, the full number of that exhibit, would it still be JX0710 and so forth on?
That's correct, Your Honor. I just eliminated the JX and the preceding zeros in the interest of time.
Right. So just to repeat back to you then, make sure I got that correct. It's information published by the North Carolina Department of Motor Vehicles, and exhibit numbers 710, 711, 714, 715, and 869.
That's all correct, Your Honor. Yes.
Right. All right, you may proceed.
Thank you, Your Honor. The next category I have is exhibits that are public information from third parties not involved in this case, and that includes federal government agencies such as the U.S. Census Bureau or other organizations. And the joint exhibit numbers in this category are 28, 29, 804, 809, 812, 814, 817, 821, 853, 854, and 873.
Okay, So the category here would be exhibits from third-party agencies not parties to the lawsuit. Is it just third-party governmental agencies, or is it third-party agencies in general?
I think it's just third parties in general, whether from public or private sources, Your Honor. I just gave the Census Bureau as an example.
Okay. The exhibit numbers I have are 28, 29, 804, 809, 812, 814, 817, 821, 853, 854, and 873.
Yes, that's all correct, Your Honor.
All right.
The next joint exhibit for admission, Your Honor, is plaintiff's notice of a Rule 30b-6 deposition that they served on the state defendants during the discovery period in this case.
Okay.
And that is exhibit number 11, joint exhibit number 11.
Okay.
Great.
Just to repeat that back, it's plaintiff's notice of a Rule 30b-6 deposition, and it's joint exhibit number 11.
Yes, Your Honor, and it's just to clarify, it's the 30b-6 deposition notice that the plaintiff served on the state defendants, not the legislative defendants.
Okay. Thank you.
The next category on my list, Your Honor, are affidavits that were entered into evidence in other cases.
Okay.
And just to clarify, Your Honor, these affidavits that were entered into evidence in other cases are from none of the parties' expert witnesses in this case. These are just exhibits from other cases, or excuse me, affidavits that were offered as exhibits in other cases, but not by any of the party's expert witnesses in the current case.
Okay.
And these joint exhibit numbers are 18, 61, 794, and 880.
800 what?
880.
All right. Just to repeat back to you then, these are affidavits entered into evidence in other cases, and it's exhibit numbers 18, 61, 794, and 880.
That's correct, Your Honor.
All right.
The next category of joint exhibits for admission is court opinions, either by courts in this current case or courts in other cases with a similar subject matter.
Okay.
And these joint exhibit numbers for admission are 3030, 816, 837 through 841, 850, 851, 870 through 872.
Okay. These, just to repeat back, are court opinions entered either by this court or other courts in similar cases. And it's 30, 816, 837 through 841, 850, 851, 870 through 872.
That's correct, Your Honor.
All right.
The next category for admission are session laws from the North Carolina General Assembly.
Okay.
And these exhibits are 16, that's 16, 400 through 402, 404 through 408, 411 through 413, 782 through 783, 868, 915, and 926.
Okay, these are session laws from the North Carolina General Assembly, numbers 16, 400 through 402, 404 through 408, 411 through 413, 782 through 783, 868, 915, and 926.
That's correct, Your Honor.
All right.
The next category of joint exhibits for admission are journals of the proceedings of the North Carolina General Assembly. And those exhibits are 421 through 426.
Okay, these are journals of proceedings from the North Carolina General Assembly, the numbers 421 through 426.
That's correct, Your Honor.
All right.
The next set of joint exhibits for admission are resolutions setting matters for consideration in either the House or Senate of the North Carolina General Assembly. And these exhibit numbers for admission are 32 and 427 through 440.
Okay, then again, these are resolutions setting matters for consideration in either the House or the Senate, and they are numbers 32 and 427 through 440.
That's correct, Your Honor.
All right.
The next category of exhibits for admission are material that relate to the legislative history of House Bill 351 from the year 2011. And there's only one joint exhibit for admission under that category, and that is exhibit 414.
Okay, this is material that relates to legislative history of House Bill 351 from 2011, and it's exhibit 414.
That's correct, Your Honor.
All right.
The next category for admission are exhibits relating to the legislative history of House Bill 1098 from the year 2018. And those exhibit numbers for admission are 416, 478 through 492, 494 through 500, 510, and 511.
Okay, this is exhibits related to the legislative history of House Bill 1098 from 2018, and it is exhibit numbers 416, 478 through 492, 494 through 500, 510, and 511.
That's correct, Your Honor.
All right.
The next category of exhibits for admission are exhibits related to the legislative history of Senate Bill 824, also from 2018. And those exhibits for admission are numbers 33, 410, 417, 418, 622 through 687, 766 through 780, 875, 876, 879, and 925.
Okay. This is exhibits relating to the legislative history of Senate Bill 824 from 2018. It includes exhibits 33, 410, 417, 418, 622 through 687, 766 through 780, 875, 876, 879, and 925.
That's all correct, Your Honor.
Great, batting 100.
So far, so good. The next category of exhibits for admission are exhibits that relate to the legislative history of House Bill 589 from the year 2013. And these exhibit numbers for admission are 100, 180, 366, 415, 540 through 607, 781, and 923.
Okay, these are exhibits relating to the legislative history of House Bill 589 from 2013, and it includes exhibits 100, 180, 366, 415, 540 through 607, 781, and 923.
That's correct, Your Honor. Okay, the next category for admission are communications related to the legislative history of House Bill 589, the same bill as in the previous category. And these exhibit numbers for admission are 390, 392, 394 through 396, 399, 403, and 409.
All right, then these are communications related to the legislative history of House Bill 589, and it's exhibit numbers 390, 392, 394 through 396, 399, 403, and 409.
That's correct, Your Honor.
All right.
The next category of exhibits for admission are transcripts of the proceedings from the Elections Committee of the North Carolina House of Representatives. And these exhibit numbers for admission are numbers 501 through 509.
Okay, these are transcripts from proceedings of the Elections Committee. What else did you say there?
They're from the Elections Committee of the North Carolina House, Your Honor.
Okay. And they are exhibits 501 through 509.
That's correct, Your Honor.
All right.
The next category of exhibits for admission are exhibits relating to the legislative history of House Bill 1169 from the year 2020. And these exhibit numbers for admission are exhibits 512 through 539 and exhibits 688 through 691.
Okay, these are exhibits related to the legislative history of House Bill 1169 from 2020, and they include exhibit numbers 512 through 539 and 688 through 691.
That's correct, Your Honor. The next category of exhibits for admission are those that relate to the legislative history of House Bill 646 from the year 2019.
646.
That's correct.
Okay.
And these exhibit numbers for admission are numbers 608 through 621 and exhibit number 927.
All right. These are related to the legislative history of House Bill 646 from 2019, and they include exhibit numbers 608 through 621 and 927.
That's correct, Your Honor.
Right.
The next category of exhibits for admission are those related to the legislative history of House Bill 836 from the year 2015. And these exhibit numbers are 726, 727, and 924.
Okay, these are exhibits related to the legislative history of House Bill 836 from 2015. They include exhibit numbers 726, 727, and 924. Is that right?
That's correct, Your Honor.
Just so I know, how far are we in this process?
We're
We do-
very close to the end, Your Honor. I only have about a handful of categories left, and most of them only have a handful of exhibits within them.
Okay. If we were at just the tip of the iceberg, I was just trying to prepare myself there.
Thankfully, we are far below the tip of the iceberg, Your Honor, or maybe that's not so thankful for the ship's passengers.
Go ahead.
Your Honor, the next category of exhibits for admission are those that relate to the legislative history of laws that are not related to voter ID at all. And these exhibit numbers for admission are 350 through 365, 367 through 389, 391, 393, 397, and 398.
All right. These are exhibits relating to the legislative history of laws that are not related to voter ID at all. And they are exhibits 350 through 365, 367 through 389, 391, 393, 397, and 398.
That's correct, Your Honor.
All right.
The next category of exhibits for admission are North Carolina general statutes. And these exhibit numbers are 419 and 420.
Okay, these are North Carolina general statutes, and they are exhibit numbers 419 and 420.
That's correct, Your Honor. The next category of exhibits for admission are North Carolina Administrative Code provisions. And these exhibit numbers are 908 through 914, 921, and 922.
Okay, these are North Carolina Administrative Code provisions. There are exhibit numbers 908 through 914, 921, and 922.
That's correct, Your Honor. And I only have 4 more categories on my list.
Okay, let's do it.
Okay. The next category of exhibits for admission are newspaper op-eds. And the only exhibit in this category is number 35.
Okay, newspaper op-eds, exhibit 35.
That's correct.
Okay.
The next category of exhibits are the exhibits that plaintiffs attached to their motion for a preliminary injunction in this case. And the exhibit numbers in this category are 471 through 477.
Okay, so these are exhibits that plaintiffs attached to their motion for a preliminary injunction. And it's exhibits 471 through 477.
That's correct, Your Honor. The next category of exhibits for admission are federal determinations under the Voting Rights Act of 1965. And these exhibit numbers are 134 through 137.
Okay, these are federal determinations from the Voting Rights Act of 1965, 134 through 137.
That's correct, Your Honor.
All right.
And the final category on my list is social media posts. And the only exhibit in this category is number 40.
All right. Social media post, exhibit number 40.
That's correct, Your Honor.
All right. All those exhibits are received into evidence in this case. And I would just remind you to make sure that along with the exhibit numbers, that for each of those numbered exhibits, if you could email that number and that brief description of what each exhibit is to the clerk, of course, along with the exhibits themselves.
Thank you, Your Honor. We'll make sure that the court receives that information.
All right. Anything else then as far as the introduction of evidence today? Exhibits.
Your Honor, this is.
I'm sorry, counsel. Go ahead.
I was simply, this is Nicole Moss for the legislative defendants, and we did have one exhibit we wanted to move in that was used today.
Well, it's the plaintiff's case in chief right now, and with their consent, I suppose you could move in an exhibit, but generally you would move in exhibits once it's your turn to present evidence.
That's certainly fine, Your Honor. We used it. It was used on cross with one of the witnesses, and it was our understanding. And I'm sorry if I didn't understand that correctly. That rather than moving it in at that time, we would wait till the close of the day. We can handle it however you'd like, and we can certainly wait until our case.
Well, like I say, I don't have any problem going ahead and receiving any exhibits that all parties have consented can come in. But you I'm sure are aware, normally parties get to introduce exhibits, introduce evidence during their case in chief, and it's the plaintiff's case in chief. So let me just ask Ms. Riggs or Mr. Simons, do you all have any objection to the legislative defendant's introduction of this exhibit?
Your Honor, I had a similar understanding, and so about the practice of introducing only agreed upon and plaintiff's exhibits during the case in chief. So if we could, I just haven't had an opportunity to confer with my colleagues about this.
All right, Ms. Moss, maybe we can do that later, but we'll just
certainly,
wait,
Your Honor.
Just wait till it's your turn. We'll probably at the day's end of when you're putting on your case and your witnesses, we may end up going through some of the same processes that we're going through right here with plaintiffs right now. I know a lot of these exhibits that they are introducing are joint exhibits, but nonetheless, it's their case in chief right now, and their turn to introduce particular exhibits that perhaps are not consented to as well.
That is not a problem, Your Honor.
All right. Anything else then for the day before we recess for the day?
Nothing else from the plaintiffs on exhibits, Your Honor.
Nothing else from the legislative defendants, Your Honor.
And nothing for the state defendants.
Okay, then tomorrow morning at 9:30, we will reconvene with the continued direct examination of Ms. Ferries. We'll do a quick breakout session, maybe for about 15 minutes, so you all can confer, and then probably around I say 10 after 5, that session will probably close. All right.
Your Honor, if it's Allison Riggs for the plaintiffs, if it's easier on court staff, we're happy to convene separately and let folks go home if that's easier on your staff.
Okay, thank you for that. We may take you up on that after today. I don't know what legislative defendant's position on that are. Do you all have a means to confer outside of the WebEx breakout session?
Yes, Your Honor, we do, and we'd be happy to do that if that's easier for the court.
Okay, let's just do that then.
Thank you.
We'll just, instead of doing a breakout session today, we'll just go ahead and recess court and go off the record at this time. I hope that you all have